So everyone, we're at 11:06, so we'll get started. Wise, thank you for taking time to join us today. This is our third webinar. I don't want to call it post, but
second wave.
Yeah, we did these in April last year. Not last year, sorry. Felt like last year. We did these in April, the spring wise, when the pandemic first started, and there were a lot of unknowns with the landlord and tenant board, evictions. There was a moratorium on evictions wise. There was messaging in the media wise that tenants don't need to pay their rent. Landlords were freaking out, for lack of a better term, because they're like, oh my God, literally the government is saying don't pay your rent or pay what you can. I have my costs. What can I do? I don't know if the bank's going to defer my mortgage. There were a lot of unknowns, and people were scared in April wise. We've gotten all through that. The government pushed through a new bill called Bill 184. Some of that has been made into law. Some of that is still pending ascension approval. I'm not quite sure what the exact terminology is, but not all of it is. Proclamation, there we go. Some of that has gone through, so we'll talk about some of that today with everyone. So we made it through, but the predominant message that we sent to April wise was that communication is key, and communicating with your tenant to resolve issues wise. Because we lost the ability of legislation, we lost the ability of government wise with a moratorium on evictions and the messaging of not paying payment of rent. You know, it became a wild west of what can I do? And there was a lot of panic, and our messaging was communicate, and work together to find a solution wise. And we continue to stress that today. And I can say that, you know, going through that in April wise, owning a property management company, doing leases for everyone, we really didn't have that many issues. I can say we only really had one issue of non-payment of rent wise that is close to coming to resolution now, where a large sum was accumulated wise, but everyone else ended up paying. There were some rent reductions, rent deferrals, those kind of things. It wasn't everyone paid on the first of the month. There were delays in payments of rent and everything like that. But I can say that, again, 99% of people paid their rent, and the landlords were able to recoup the rent. Now, what did happen though, we had tons of people give notice and vacancies and everything like that. You know, those things did happen. You did have negotiations again of tenants on month to month going, hey, I'm not paying 2019 rental rates anymore when I can go rent something for less wise. Are you willing to renegotiate the rent? You know, all those things did happen wise, but through communication, again, 99% of the issues were resolved, and money was exchanged for accommodations wise. So that's everything there. You know, for those that don't know us, I'm Alex Wilson, Remax, broker owner of Remax Wealth Builders Real Estate, co-founder Kyle, beside me of Remax Wealth Builders Real Estate. We have about a $17 million real estate portfolio. And then again, we have Elaine Page, award-winning paralegal. Lawyers don't handle rental cases. For the most part, it's paralegals that deal with these rental issues. They are the experts in this area wise. So we brought in our expert. Elaine is the recipient, past recipient of the Paralegal of the Year for Ontario wise. So we bring in only the best to speak with us. And yeah, so this is number 3 of our series in November wise. So Elaine, what should we start off with today? Anything burning your bonnet that you wanted to add, or any experiences from the past week?
Yeah, I wanted to just share a couple of updates. So first of all, last week we had a whole discussion about rent reductions and how I was advising because of the complexity of doing them and the risk of turning that lower rate into a permanent rate was high. I told you, I think, that I was on a bit of a rampage about this because it's such a huge issue. So I have actually reached out to several MPPs at this point, and I'm trying to get a private members bill to push through an amendment to the sections and the regulations of the act that limit rent reductions. And I think it'll be, if it happens, it'll be hugely beneficial for both landlords and tenants, because then they'll have the flexibility, more flexibility in working with their tenants. And it's a bit of an anomaly because you keep hearing the government say, work with your tenants, work with your tenants. And then when you work with your tenants, you get screwed. So I'm trying to get that rectified, and hopefully have some more news on that soon. Section 83 of the act was amended under Bill 184, and that this piece has been proclaimed. And it basically says that you have to prove that you tried to work with your tenant with respect to rent arrears. Otherwise, you will not get an order at the board terminating the tenancy. So back in April, I had suggested that you write to your tenants and try and make arrangements for payment plans. And that was just a hunch I had. And as it turns out, I was right. It is now law. So for those of you who are here who may have tenants who are in arrears, it's really imperative that you go ahead and try to make some payment arrangement with them. They may not respond to you, which is what happens in most cases. But if you end up at the board, you're going to want to be able to prove that you did a reach out. So Keith says, I have rent controlled unit, tenant wants reduced rent with month-to-month government freeze rent for 2021. So Keith, this is exactly what I was talking about. There are all sorts of issues with reducing your rent. And I don't recommend it at all, because it can get you into a lot of trouble later on. The fact of the matter is that the Ontario government has frozen rent increases for the year 2021. So the best advice I can give you is keep the rent the same. You may want to defer, like for example, if the rent is $2,000 and they want to pay $1,800 a month, you can do a rent deferral, but not a reduction. And the distinction is, a reduction means it's never owed. A deferral is an agreement that says it is owed sometime in the future, and set a date no longer than 11 months for that.
Okay, and Keith, what building are you referring to? Because it also, if you are in a building that is not subject to rent control, then it doesn't matter.
Well, it does matter in that it does matter, Alex. So if it's not subject to rent control, potentially if they reduce the rent, the way the whole rent reductions happen, you could be setting the rent at the reduced rate. It's
that's fine.
Convoluted.
Then I'll increase it down the road.
Right.
That's what I mean. It doesn't matter in regards to, I have not in 2021, but anyone that's worried about 2021, rental rates will still be crap in 2021. Don't worry so much about 2021. Rents are frozen anyways. Your recovery is going to be in 2022. And if you're in a non-rent control building, you have the ability to increase the rent as long as you're on you can increase the rent with 90 days notice as long as the tenant is month to month on the property wise. Again, not in 2021, rents have been frozen across the board. But again, don't worry about that, because rents will still be crap in 2021.
Right, and if you are increasing the rent, whether in either way, if you're part of rent control or you're not, there's a Form 1, which is the legal document you must use to increase the rent. And I think there's also a Form 2 if you're not subject to rent control. You have to serve that particular document. If you what happens a lot of times is landlords will just send a note going, hey, just to let you know, your rent is going up by $50 starting March 1st, 2021. That's not a lawful rent increase. And at some point the tenant could say, sorry, I'm not paying it. So use the right form. You can get the form on the Landlord and Tenant Board website.
Do you have to email that or actually physically mail it? Is there a requirement?
Yeah, I mean, it's not one One of the problems with emailing documents is that in the new standard lease, it says that you're allowed to email documents, except only those that are prescribed. And then they don't really have a clear list of what's prescribed. So until that gets fixed, I would send it by regular mail.
Or do both. Do both.
Or do both, yeah.
No, do both. Always email it wise, but send on mail as well to cover the back end too.
Yeah, like N4s, which are notices of termination for non-payment of rent, they cannot be served by email, and I'm getting a lot of files in where individuals have done that, and I've said, I'm sorry, you haven't properly served this. And some we've managed to save, but not too many. So what I'm doing now when I do an N4 is I'm serving by email as a courtesy, and I identify it as that it's a courtesy and that they should expect to find the hard copy in the mail. And it prevents, like, there's some people who are holed up in their condo units and they're not even going down to check their mail. And it prevents them from saying, I'm holed up and I'm not going anywhere, I'm not checking my mail. The other thing while I'm at it, and then I know I'm kind of jumping around, but I just wanted to make this point, is if you don't already have your tenants' email addresses, even if you're not serving them documents via email, you should get it, because the board is virtual now. And the way that the board is serving notices is via email. So you're going to get a faster hearing if you have your tenant's email address.
I'll also, and I want to go back to Keith as well. And we talked about it last week, just in regards to rent reductions and everything like that, while that's being clarified. Keith, it doesn't matter. So where it comes down to is that, I'll give a hypothetical. Let's say your rent's $2,300 per month and your tenant wants to pay $2,000 per month. And that's what the market says is $2,000 per month. And he's like, or he or she's like, Keith, you don't give me $2,000 a month, I'm going to go rent something else. Rent during 2021 is still going to be crap anyways wise. So you're still better off just going to the $2,000 a month rate, because what's going to happen, the tenant will leave and they'll go rent something else. And then you'll be lucky to get $2,000 per month, and you'll have to pay maybe a fee to get it re-rented wise, or if you're doing it yourself wise, you go through the hassle of showing and everything like that during a lockdown wise. So really, at the end of the day, the tenant has you over a barrel. The tenant wins. As long as it's within market parameters wise, you're going to have to agree to a reduced rent wise. That's the reality of the situation. To think that you're able to stay at 2019 levels wise, it's just not the reality anymore. And tenants hold the power. And again, 2021 will be another bad year for rent wise. It's not going to fully recover in 2021. So you'd eclipse the 11th month period, most likely, that we've talked about anyways wise. So is it a bad situation? Yeah, it's a bad situation. It's not a great situation, but it doesn't really matter, because even with the convoluted idea of rent reductions wise, you're not going to see a big yo-yo impact again in regards to rental rates increases anyways. They're still going to be in crap in 2021. So you're better off maintaining a tenant that pays you on a monthly basis wise, and not have to go onto the rental market right now. We've done our analysis wise. We've talked about profit on the recovery for individuals for renting out units wise. I'm using the word wise, sorry, for renting out the units wise. I just did it again. For renting out their units, and the amount of units that are available for rent in downtown Toronto right now is there's nearly 7,000 units available for rent. We're nearing a 400% increase over this period last year wise. So it doesn't matter. It doesn't really matter. It is what it is, and you're better off having monthly rent than as opposed to having nobody paying rent to you right now. And I had someone call me from England last week. They just upset and angry and going, "What can I do?" I'm like, "Nothing. There's nothing you can do. I don't want to sell. Okay, don't sell. I don't want to reduce my rent to that much. Well, that's then leave it empty was like that's what the reality of the situation is. But you're better off having money coming in than no money coming in at all. I've had to deal with it. Kyle's had to deal with it. But I'll add this, and I tell people this. Okay, so let's say you you're like, you know what, I don't want to take a reduced rent. I'm going to sell. Well, I'm going to have to sell your unit on a discount for you, and let's say that unit is worth $50,000 to $100,000 more in 2022, because that's the reality of what it'll be compared to what I would get for it now if I were to sell it. So let's say you have to reduce your rent by, let's say $300 per month. Let's say $300 per month. Over a 12-month period, that's $3,600. $3,600 versus $50,000 to $100,000. That's how you need to pragmatically look at your portfolio wise, balancing the cash flow and balancing the appreciation you expect. You only lose money in real estate when you sell. So don't sell. So never put yourself in a situation when you have to sell. So you don't need to sell right now. You will get some sort of cash flow coming in. It's not going to be the cash flow you were getting before, but that's okay because you still have money coming in. And if you wait until 2022, then that's when you want to exit the asset wise. You can exit the asset in 2022 and you will make $50,000 to $100,000 more, or even more than that, potentially on the property wise, depending on the asset class and everything like that. So you need to look at it a bigger picture, not on the fact that you're going to get $2, $3, maybe $400 less next month. These are rounding errors compared to the overall picture of the total value of the asset wise. Sorry. So Keith, I hope that helps you out. It's not a bad thing. It's not a bad thing at all. Having a tenant that wants to reduce the rent is not a bad thing. The good thing is they're staying in the unit. The bad thing is when they give you notice. That's the bad thing right now, because then you don't have someone paying you rent anymore. The bad thing is when the tenants are, well, actually even worse is when a tenant is in there not paying you rent. That's a bad thing. Tenant rental reduction is not a bad thing.
So let me just jump on that for a minute, Alex, because something has been coming up more and more, and I keep getting a lot of questions about it. We're getting a lot of situations where people are still on their lease and they are giving notice. Let's say the lease starts January 1st, the December 31st is termination, and they're giving notice to leave in November or what have you. And landlords are saying, but I have a lease, and what should I do? And the act really there's a ton of case law on this point, and I could give you, the 35-year history of how this all evolved, which I won't do. But the act basically allows this to happen. And so the begs question, why do we actually have rental leases? And I don't have a good answer for that. But it really, there's penalties around, the maximum you're going to get is 2 months. So for example, I have a case now where in this particular case, it's a 2-year lease. It is a high-end property. The rent's about $4,000 a month. And there's still, I'm going to say 13 months left on this lease agreement, and the tenants want to leave. They can't afford it. They're moving back to their country of origin. And the landlord was desperately trying to make some kind of agreement that would hold them to the remaining parts of the lease. And I'm saying to them, look, they're going to not even be in Canada anymore. So how are you going to collect on that? It's not going to happen. And then the landlord also wanted to include all sorts of clauses that are contrary to the act. And when you have clauses that are contrary to the act, they're not binding. And I always use the example, you can, put in your lease agreement that the tenant must hop on one foot every third Thursday of the month for 15 minutes, and it's all great, it's in there, but it's not binding, you can't enforce it. And as is the case with these agreements. So what I want to just tell you is what I've been advising this particular client is to assign the lease. And I want to distinguish the difference between an assignment and a sublet because they're often confused. So let's say I rent Kyle's unit, and Kyle and I have a lease agreement that it expires August 31st, 2021, and I want to leave now. If I am off to, a safari for 3 months and intend on moving back into the unit, I can legally sublet that unit to somebody for a 3-month period. And the flow of rent is That person pays rent to me and I pay it to Kyle. And that's a sublet. It's a finite term. An assignment is there are, a year and a half left on this lease agreement or whatever it may be. And I find a new tenant and subject to Kyle's approval, that new tenant comes in and takes over, steps into my shoes as tenant on that lease, and I'm out and completely out. And that tenant is now Kyle's tenant, and that lease has been assigned. And there are certain things that should be on assignment agreements. And I know that there are lease agreements that say no sublets and no assignments, which is not lawful. It's subject to, the landlord does have first right of refusal. You should distinguish between a sublet and an assignment. I will also say this piece also comes up sometimes where tenant is on a month to month and they want to assign or sublet, and it's not appropriate. It cannot be done. There's nowhere in law, once the termination date is a fixed date, and you can't just sublet month to month after the lease has expired.
I want to, Elaine, this will be one of the fun questions today. What it was is, so there's a unit, 2-bedroom, 2 occupants.
Yep.
2 male occupants, friends, got into a physical altercation, a domestic. The police were called and charges were laid. Now they want to terminate the lease.
Okay, so there's this new form that came out this year called an N15, and an N15 is a tenant's notice to terminate based on either themselves or a child being abused, physically harmed, and that it is dangerous. So a tenant can give you an N15, and as a landlord, you actually cannot tell the other tenant that you received the N15. You can't advertise the unit. You just have to accept it. With that, N15 is a document which says it's a form that you do check marks on, that basically says there's a file with the police open, or my partner's been charged, or there's no charges but there's abuse going on. And that's all they need to do. And once that happens, that's it. They have terminated their particular tenancy. The problem with that, although it is a good idea to put something like that in place to protect people who are in abusive relationships, the back end at the landlord and tenant board is that if we find out that someone's just made that up, that there is no abuse going on, it was a mechanism to get out of the lease, there's really very little recourse. So I can't bring an application to challenge somebody's N15. There is no application available. So what I've been getting in the last few weeks is people who are living alone and filling out N15s. Now, it may be that a former partner is showing up at the unit and being abusive. That may be happening, I don't know, but it seems like somebody probably put something out into the internet, into social media saying, hey, you want to break your lease? File an N15. And so be wary of those. I've got the garbage truck, so I'm just gonna close the windows. Okay, now what's that?
No problem. And we made a request for the police report to confirm that there was actually a physical altercation that happened, because they said their charges were laid. So it becomes
a question of, is it one person wanting to break the lease, or is it both parties? Because each tenant is jointly and severally liable, right? So if one person wants to leave, the other person wants to stay, they get to stay, and they then become responsible for the entire unit. One of the other things I would say from a practical perspective, it's likely that what you're referring to is a condominium. And if that kind of activity is going on in a condominium, it's very likely disturbing other people in the condominium, and you're going to be getting complaints from the condo board, and then they get their lawyer to send a letter for $800 that you as a landlord have to pay for. So it's almost better just to say, okay, you know, sorry that you're having these difficulties. Sure, let's let this tenancy end and everybody shake hands and walk away, because down the line you may have much more serious problems.
Yep. So when that came up, great answers wise, and something I never thought of before. But two potential roommates or two roommates getting into a physical altercation where there was assault charges laid. These things do happen. So there is your answer for that.
Yeah, and they're happening more and more because people are struggling with mental health issues because of COVID. So we're seeing a huge flare up of mental health issues.
You know, that's a great point. So envision this now: two people rented a unit together. They were anticipating going to work every day and then coming home in the evening. Now you're in, let's say, a 700 square foot space, and you can't go to work. You're working from home. You are in each other's face 24/7. Specifically now, because these units are in Toronto, so you're technically not supposed to go anywhere. So you're in each other's face 24/7. One person's a loud eater. You know,
it's a Seinfeld episode.
Oh yeah, you know, you're trying to do a conference call and work wise, and then the other person's doing something else wise. It just builds and builds and builds. Now I'll add, these were both males in this situation why it builds, and then boom. So yeah, it's as you bring it up, you're seeing an increased number of these, but it makes sense. You know, you have two individuals that were trying to save money living together wise, and it's just a pressure cooker situation because their original intent of living together didn't state that they were going to be 24/7 each other's faces. There was supposed to be a reprieve of 9 hours every day where they were actually going to the office wise. Those reprieves are gone. It's going to be a long winter. You know, we'll see more of these cases come up. So
right, but we're seeing it. I mean, we're seeing that scenario, but what I'm actually seeing is not that scenario is good, but people who have been, you know, have diagnosed mental health issues, who require meds to maintain their stability, and for whatever reason aren't taking meds, and in fact are taking recreational meds. And I can't tell you how many in the last 2 weeks tenants we've had to pull out under mental health because they've just gone over the edge, and it's really, really sad to see it happen. But they are actually so far over the edge that they've become dangerous to everybody. So we are seeing that, and you need to be mindful. And so one of the things I'm going to say to the landlords out there, if you suspect that's going on, you need to tread very lightly. You know, mental health, a lot of people there's a stigma about it. People think it's funny. It's not funny. It's a serious disease, and these people are suffering. And if you start poking the bear with somebody who's going through a serious mental health issue, you're actually making it worse for both yourself and the person. So you need to tread very, very lightly.
And I'll add this to it. Let's go to the next level wise. You know, they're someone's contained. They're having issues wise. They're maybe self-medicating. They're in a very, very bad spot. What's the next thing that can happen? Forget about ending the tenancy. What if they end their life? And now you have someone that's ended their life, probably in your unit. Which is very, 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 very sad. But can you imagine? Again, you're very sad, but also all the other stuff as a landlord you're going to have to deal with that. You know, there's tons of stuff. So yeah, Elaine, you bring up a great point. Don't poke the bear if you suspect there's some issues coming on. Reach out to the person. You know, be supportive. This comes back to communication wise. 95% of the people are not out there to screw you. This is someone's home. This is your asset wise. 95% of the people aren't out there to screw you. Maybe about 5% are, but 95% aren't. So if you act like a human, the human on the other end is going to treat you like a human as well. That may seem a little fluffy, but we are dealing with, I mentioned it before, Maslow's hierarchy of needs, food, shelter, warmth. You're providing shelter, a fundamental need for individuals wise. This is someone's home. There's a lot of stress on that individual to maintain that property wise. As an investor, this is a major asset for you, part of your investment portfolio. There's lots of stress for you. Sometimes it's great to bring a third party in. Elaine is your third party in these situations. If you really suspect something is going downhill wise, I do encourage you to reach out to a professional, whether it's Elaine or someone else, because if we talk about the mental health issues that are coming up or that already exist, they are only going to get worse this winter wise as we get locked down. Kyle, now I'm sitting here and I was getting upset this week when I read the email that went out from one of our buildings that we both have an investment in. The bill, it basically says that you're locked in your unit and no one can come see you. That's how the email read. And I said to my wife, I'm like, wow, I'd be pissed off if I got this. What are you saying that no one can come see me in my unit wise? That's literally what the email says. It says no one can come see you in your unit wise. I'm like, that's absolute ridiculous wise.
I'm not sure how binding. I'll be honest with you. I've seen condos doing that. Like my mother is 90 years old. Thank God she's well. But we do her shopping and we go, my brothers and I go and see her a couple of times a week just to check in on her and whatnot. And are you telling, if I got stopped by the concierge who said to me, I'm sorry, you can't go see your 90-year-old mother who, is all by herself alone in her unit, I'd have a few words to say to that concierge.
Oh yeah. Yeah. Like that. And so you get the, now I would say we're all rational individuals in here. We're gonna, tread within the spirit, let's say, of things that are going on. But there are individuals that are gonna get that. And someone that's on the edge and you get that email wise and you don't know what to do and you're already in a bad state, that is gonna freak you out even more wise. So there is so much tension out there, and that's what's happened. Like, again, that email wise, I read it. I was shocked. We had a client reach out to us immediately wise because we have to rent out his unit, and he's like, well, how are we going to do this? I'm like, don't worry, we'll take care of it. But like these are the things that these undue pressures that are being put on people and individuals that can't see the rationale or deal with the rational aspect of that because they're reading the letter of the law and they want to abide by the letter of the law, and they're in a fragile state, and then you go poke them. It's bad, and I understand why you may want to poke them because you're frustrated because of financial aspect wise. You're worried about your own family and your own assets and what you're going to do and everything like that. So stressful on both ends.
Right. And the other thing I want to say about that is if you have a tenant who hasn't been paying their rent and they're having other issues, at a certain point, and I'm happy to kind of walk you through each case on an individual basis, it makes sense to just cut your losses and call it a day. You haven't been paid 8 months in rent. I hear you, and I know it's terrible, and I know you have to still pay your mortgage. I get that. But it may be another 6 months before we can get this person out of the unit, and we don't know what, if you think the unit's bad now, we're not going to see it in 6 months from now. So in those cases, it is sometimes better to just make a deal and let the person go and sign a full and final release and be done. Especially now, we've gone into lockdown in Toronto and Peel region. I'm seeing that we haven't even hit the peak of our second wave, and that the tenants' rights groups have started flaring as of yesterday or the day before with demonstrations. And there is a real possibility that the board could shut down again in the next month or so. It's an absolute real possibility. I don't have any inside knowledge, so I'm just speculating. once they get caught up with all of the files that have been, the 12,000 files that have been in abeyance over COVID, I could see them closing down again. So if they close down and they're closed down for 4 or 5 months, and then it's another 4 months to get a hearing, you know, now you're losing a year and a half's worth of rent, and your place has been toasted. So be business savvy. This is your investment. And sometimes you have to lose a little bit of money in your investment to gain a whole lot on the other end.
Yeah, and if you're struggling with that, you know, reach out to myself, reach out to Kyle, and we'll just tell you what it is straight up. It's not a bad thing. We'll go back to my example wise in regards to 2022. Well, your asset's going to increase in value in 2022 again, in regards to 5 to 6 figures, in regards to what the value is right now. So you may have to take a hit now, but there's light at the end of the tunnel.
Absolutely.
There's 100% light at the end of the tunnel. Something else I wanted to add, where Elaine was just talking about the landlord and tenant board, you know, they're only seeing cases now from March and April, from the backlog from before. So if you were to file something right now, it could literally be 6 months, and then who knows if they're going to shut down again, which Elaine says this is just her spitballing. She has no inside information. But if you think of the reality of it, winter's coming. The political optics of putting people on the street during winter wise, not good. So there could be a political motivated aspect to shut down the landlord and tenant board. Have we seen changes to the act that have been politically motivated before? 2017, April. That's all I have to say. So it could happen wise. So this is where communication with the tenant is key wise, you know, whether it's a rent reduction, whether it's just being a shoulder to hear them. Kyle was a shoulder to hear his tenant wise.
Yep.
He got paid and everything like that. He had a tenant that was a bartender wise. Clearly that person wasn't making money. That tenant paid every month. He was just there to support that person. They recently moved to a different unit wise. Where was it going with this? Be the shoulder. And then as Elaine said, worst case scenario, maybe you got to cut your losses. But these aren't the end of the world situations wise. It's how you navigate the rough waters. Now, you know, we've been chatting a lot. Let's open up the questions wise. We got 8 sitting here already wise. We want to finish this by noon. So we'll jump into it right here. Kim, starting off. Hi, I'm joining late. Elaine, did you mention how any of your hearings went? Some of the things I've read online, the hearings seem to be going quickly. I've tried to negotiate with the tenants and I'm getting stonewall. They said they're leaving, but never do.
Okay, so very quickly, the hearings are going well. It depends on the adjudicator. The adjudicators who were disorganized or less organized in-person hearings are less organized in virtual hearings. The ones who were well prepared and very organized are exactly that. They are in virtual hearings. So I have had a couple of issues around one particular hearing, which was an emergency hearing, and it related to smoking in the unit and the effects on the landlord. And the adjudicator was not able to upload our evidence package. And it was quite problematic because she was literally having me, you know, hold up documents to the screen like this so she could read them. And that, you know, so that kind of thing does happen. For the most part, the hearings have been going pretty smoothly. I will tell you, though, that some people have not gotten notice of their hearings. So if you do have an outstanding application, you should go onto the Landlord and Tenant Board website, check your file status. You plug in your file number and the postal code, and it'll tell you the status, because there may actually be a hearing that you don't know about. So that's that. I've tried negotiating with tenants and I'm getting stonewalled. Yeah, as long as you try to negotiate, you have complied with Section 83 sub 6. So don't worry about it. I'm going to move on because I too am mindful of time. So should I email the LTB with the email address? So Kim is talking about my statement around collecting your tenant's email address. Yes, Kim, you should send an email to the LTD saying, with your file number on it, and say you are the landlord and you now have the tenant's email address. Here it is. And they'll, please attach it to their file. You should definitely do that. Okay, Keith, do I have to indicate new and old rent in lease renewal? Well, this goes back to whether you actually should be renewing a lease, like for another year, or whether you do continue on as a month-to-month. From my perspective, I really believe in month-to-month tenancies because there's all sorts of notices that are only available at the end of the term. For example, if you want to sell the unit, you can only have vacant possession at the end of, if you renew for a year, at the end of that year, versus if you're month to month, you can do a notice for 60 days. And in this market, and I mean, I'm not the expert on the real estate market. That's Kyle and Alex, and I know that they've said this is not the time to sell, but some of you may not be listening to them and still want to sell. So you want to make sure that you have the ability to do that. So I wouldn't even renew a lease.
And I'll jump in and add, and I've said this to people even before we had our conversation today. What's the point of renewing wise? It only benefits the tenant. It doesn't benefit you. The reason is, if the tenant takes off, what's your recourse? There is none. You really don't have recourse wise. So is it going to make you, is it just going to make you sleep better at night that you have this piece of paper that says you've renewed for another year? So it only benefits a tenant because they've secured their address for another year.
Right.
And you can't break that, but the tenant can just go, yeah, I'm taking off. What are you going to do? So only go month to month wise, because it reduces your options after the fact, because you really have no recourse if you renew it anyways.
Perfect. So Mary Lou's asking, can you clarify main grounds for evictions? Most evictions are for non-payment of rent. There are other evictions available for things like purchaser's own use, owner's own use, if you need to do massive renovations or you're demolishing the unit. And then there's behavioral issues, and there's a whole other class unto itself. If the tenant is doing something that is seriously interfering with reasonable enjoyment or infringing on the rights of the landlord, that is grounds for termination. It's a very difficult application, by the way. And of course, if illegal activity is going on in the unit, that would also be grounds. So those are the basic ones. I probably missed something in there, but if I did, it's pretty rare.
Yeah, those are and one thing to add to, don't lie.
Ever.
Don't lie to the landlord and tenant board. Don't do that, because the fine
get caught.
The fine and the fines have increased from what they were in in the new bill 184. So the recourse that you could have against you is significant.
So you're referring specifically to the applications for own use or purchaser's own use, which have been very abused by landlords as a backdoor to get a tenant out. And so consequently, Bill 184 addressed the abuse, and that's why the fines are so high. And don't do it. Absolutely do not do it. Okay. Kim says, oh no, I added the emphasis. Hearing dates are being assigned for applications filed and made. Yeah, it's weird. They're all across the board. I have some from December of 2019 that I'm waiting for, and other ones that I filed in May that I have hearing dates on. So it's all across the board. If you have one from 2019 or early January, February of 2020, and you haven't got a notice of hearing yet, they come via email, by the way, then you should maybe write to the board, because I'm sure that they're so overwhelmed. They're working from home. They may have missed your file. They'll probably send you back a snooty reply saying we have 20,000 files or whatever the number is, and you're in line. But just in case something has gone awry, even though they're giving you that answer, they may actually look into it and find it for you. So, all right.
I'll handle this next question. Wise, 2 of our units are vacant with with the lockdown, will my realtor still be able to do viewing? Well, it depends on what the regulations building is, but if the units are vacant wise,
Shouldn't be an issue.
it shouldn't be an issue, even if the building has some sort of policies in place. There's always workarounds.
Yeah, and I think in the first wave, Real Estate Council of Ontario set some guidelines around this for their members. And I mean, obviously we want to keep people as safe as possible.
Yep. I'll let you jump on the next one.
If one of the tenants leaves, should I make that amendment before the hearing by email to the board? No. No, it's a joint and several lease. We have a case that tenants in Hamilton, 17 in arrears, haven't paid. We had a hearing, other hearings took place, ran out of time. Adjudicator set another. Oh, so I'm just going to stop there because this is a very specific question around a particular case. But I do want to make the point. I have many applications where there's more than one issue. So, but the application before the board is about non-payment of rent. My clients want me to bring all of the other issues in, and I keep saying I can't do it. The application is only about non-payment, not about their utility payments, not about your N12. We're only talking about this. And the problem is if you start at, you have to be so efficient in your virtual hearings because it's a small window of time. And if you run on at the mouth and don't follow the instructions of the adjudicator, your case may not finish and you may end up waiting several more months to get a hearing. So be super efficient in at your hearings if you're doing them yourselves. I haven't read the rest of this, Maria, but it looks like this is a case that's before the board already, and I'm uncomfortable commenting on something that is before the board.
Yeah, and then the next question is the next 4 or 5 comments here. So I'll let you read into that quickly, Wise.
Okay. So this is from Noor Jahan. Forgive me if I pronounce your name incorrectly. Tenant stopped paying at end of first year. Okay, first and last were exhausted. That should not have happened. The last month's rent should only be used for the last month of the tenancy. She stopped paying, refuses to work. She would ordinarily be due for an annual increase, but I'm prepared to continue at the old rate. You don't have a choice. There are no increases. She does not respond. You've served an N4. Okay. So does she get to live rent-free to 2020? You know, Nor, you need to make sure first of all, that your N4 doesn't have any, what we call fatal defects, that it was done correctly. And if the time is up on the N4, you should be issuing an application through the e-file system, and you will get a hearing date. But the first thing you should be doing is checking your N4 and making sure it's done correctly. And then you say, I know my tenant and has her boyfriend living with her and her 2 daughters. She's expressly told me that she and her 2 daughters will be the sole occupants. Do I have recourse? No. So this comes up quite a bit where we think we're renting to one person and 3 people move in. And it's a square footage bylaw issue that tenants are allowed to have roommates. And the bylaws in each jurisdiction specifically define how many people can be living in a space and by square footage, and the kitchen and bathrooms are not included in the square footage, and children are not included in the definition. So, you know, you might have one person with 6 kids in a 1-bedroom, but they are not actually breaching the bylaw. So you have to check the bylaw. And if there is a breach, then there is an application available for that.
Great, perfect. Well, that's all the questions. Everyone, thank you so much for joining us today. I hope we help answer some questions. But again, don't stress out. You'll get through this. Communicate with your tenants, Wise. And if you are having communication issues with your tenants and you're at wit's end and you aren't in the process of being with the board, Wise, and you don't know what to do next, reach out to Elaine. She's going to be able to help you out in these situations wise. And it's time for, these are the times for straight talk. So Kyle and I'll give you straight talk. Elaine will give you straight talk. It's not all, the number we come back with probably won't be the number you want to hear, but it's an answer and it gives you a way to move forward. And that's what you want to do now. So this recording will be sent out to everyone wise. That'll probably go out tomorrow to you. Thank you so much again for attending. Elaine, thank you so much for your time, and we'll talk to everyone.
Thank you for the invitation and the opportunity to spend time with you guys and go through all this. It's been most enjoyable, and so I just want to say thank you.
Oh, no problem. We always appreciate it. Okay. Thanks, everyone. Talk to you.
Bye, everyone.
Bye.